Great nation like great men should keep their will. Ours is written Constitution. The promises it makes to the people and the state alike are not hidden. Separation of power. The sovereign immunities of the states, separate from the federal jurisdiction. By virtue of the state constitution, which is an evidence that each state can govern themselves because they have their own governing law, albeit preserving the integrity of the same substance at a federal level, but nonetheless, each state have their own sovereign powers. In the matter before the court, plaintiffs challenge an unprecedented law known as the Corporate Transparency Act. It represents Congress' attempt to combat bad actors' ability to cloak their criminal activities and avail of corporate anonymity. At its most rudimentary level, the CTA, which is Corporate Transparency Act, regulates companies that are registered to do business under a state's law and requires those companies to report their ownership, including detailed personal information. I repeat, including detailed personal information. They're going after you, the everyday man, who are trying to really be free by intertwining trust with LLC, because now they're realizing a larger population of the everyday man are slowly, but surely figuring it out. If you really want to know how things are done, look at how these businesses are using it. People just hate business, and people just hate money, and people just hate entrepreneurship. People just hate wealth, that they run away from things that benefits them rather than learning and growing. Limitation mindset, screw you up. Grow. The third party saying, oh no, you got to do it. You just got to file that FinCEN stuff. There's no other choice. It's the law. That's the stuff you'll see most of people going on about FinCEN on YouTube, just pushing because they are benefiting from it one way or the other. Some people get the clever idea they can upload their foreign trustee's passport, but even you are, for lack of a better term, screwing yourself up by doing that. So I didn't show any of such information on there. And the reason is because of what I'm about to show you here. Majority of this thing you call freedom is just based on you standing up and speaking up for yourself. Hello, beautiful people. Welcome back. Remember the video that was done on the Corporate Transparency Act, the first part and the second part? Where particularly it was mentioned that LLCs, in short, starting this year, 2024, people are being compelled to now show who their substantial parties are. And then in the second part, I show you, look, here are exempt entities, and here's the reason why I've been telling you, just go create a 508 entity. And the reason why I have shown you how to properly set up an LLC if you find that you, by all means, need to use it for whatever reason, which could be useful or could have substitute, up to you. Now, if you pay attention, I went into the FinCEN website.
So, where does the self-confession take place? They use the term submit or report. Double speak, just to make light of it. But in truth, it's self-confession. The website is bsaefiling.treas.gov/main_HTML. This is what it looks like. BOI e-filing. You click it. You then go ahead and click File B or IR. It gives you the different format to which you want to file it. Gives you a warning, this is a government website, blah, 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 meaning everything you put here, your IP, from where you're doing it, we have your information. As for the DBA of it, as for the EIN of it, social security number, whether it's foreign or not, as for the address, as for the company, the FinCEN ID that they would issue to you to tax you. It would ask you what type of document you're submitting. Foreign passport, right. If you're so deep into it, there's always a way out. But you should create your own way out rather than using the way out that they created for you. Because at any point in time, if they see a lot of people are getting hip to this, they would snatch this away from the equation. You can't say you've not been told. Country jurisdiction, you can choose it. This is where W8 Ben and 8832 comes in. And then it goes to the beneficial owner and all that other crap. You put all that there. You go to submit. Compliance reminder. You are our slave. If you willfully fail to report complete beneficial information, you are screwed. Oh, and in the note of that, the reason why I tell you, just do it the right way outside of whatever is going on here. Because they have a lot of loopholes to their benefit. They have penalty, civil.
But I did not tell you to upload anything. Some people get the clever idea they can upload their foreign trustee's passport, but even you are, for lack of a better term, screwing yourself up by doing that. So I didn't show any of such information on there. And the reason is because of what I'm about to show you here. Over the past few months, many different entities, privately and the ones who do business publicly, have been basically suing the Attorney General of the United States, because they are basically the one that all that goes in the lap of, and they're ultimately the ones who will sue anyone who fails to abide by that FinCEN website regulatory procedure. So a federal agency in short, and their attorneys is the U.S. Attorney General. So the appropriate party to sue is the U.S. Attorney General. The first state that really made a difference when it comes to the Corporate Transparency Act, which is reasonably predictable that most people will not just sit there and make it work, because the assumption is, well, there are people who move narcotic and do other things with firearms and tobacco, and they're using Shelf Corp and just a placeholder straw man of LLCs as a front. Even though we know that's really not the truth. They're going after you, the everyday man, who are trying to really be free by intertwining trust with LLC, because now they're realizing a larger population of the everyday man are slowly, but surely figuring it out. So that's their way of using legislative front as a warfare. But in the midst of doing that, they didn't account for the fact that there are other, generally speaking, entities who just do stuff out here that are not going to stand for that, even if they're everyday men who it's meant to affect have no clue what's going on. They just follow along in line because there's a default of them going into agency. Going into agency meaning they love going to third parties to say, hey, what do I do about this? And the third party saying, oh no, you got to do it. You just got to file that FinCEN stuff. There's no other choice. It's the law. That's the stuff you'll see most of people going on about FinCEN on YouTube, just pushing because they are benefiting from it one way or the other. Well, many people have been pushing back. And Alabama was one of the states that basically passed an injunction to say, no, not in this state. Any LLC is created in this state. No, we're not doing that. I think 2 other states followed up, but I did not make any video on that purposefully because some of those are currently still in appeal stages on a state level. One of them is in an appeal state on a federal level. But this particular one I'm about to show you actually has a result directly on a federal level. And it originated from the venue of Texas. Now keep in mind, federal courthouses can do business in different states. So if the federal jurisdiction within the venue of Texas passes a decision, even though it's just for Texas, it can be applicable to all 50 states. And this is what this particular case led up to. They made it to apply to all 50 states. Skipping track of this case also, and I was waiting to see how it was going to turn out, and I suspected it will turn out this way. That's the reason why this is the particular one I'm making a video on. So let's take a look at it, shall we? It's case 4:24CV00478. It's at the Eastern District of Texas. Today is the 4th of December. I'm not sure when I'll eventually upload this video, but the order was passed yesterday, the 3rd, memorandum and order. It's therefore ordered the plaintiff's motion for preliminary injunction is hereby granted. Well, in other words, preliminary means some other stuff is to follow. Something tells me that what will follow will be in line with this. But the significant part of this order is not just that it's limited to Texas, which is why I'm showing this. significant part of this is that it applies to all 50 states. So let's take a look at it. Again, case 4:24-CV00478. Document 30, December 3rd, 2024. Texas Top Cop Shop Incorporated, among others, is the plaintiff. The defendant, Merrick Garland, who was the Attorney General of the United States, among other entities. Memorandum, opinion, and order. This is a 79-page document, but we'll go to the core of it just to get straight to the point. Remember, this is not the final conclusion because this can still be appealed, but everything that's going to be appealed will follow the pace of what the plaintiff has done, who's the master of the complaint, and what the order in their favor has done. Pleading before the court is plaintiff's motion for preliminary injunction. Through it, plaintiff seeks to enjoin government from meaning against, enforcing the Corporate Transparency Act. Through it, plaintiffs seek to enjoin government from enforcing Corporate Transparency Act and its implementing regulation, meaning the fees of $500 with inflation in consideration, so $560 or $570 for penalties of those who don't do so. Having considered the motion, the argument of counsel, and the applicable law, the court concludes the motion should be granted. Great nation like great men should keep their will. Beside the case law. Ours is written Constitution. The promises it makes to the people and the state alike are not hidden. So they're showing you right from the start that the constitutional principles is the reason why the Corporate Transparency Act is being barred via an injunction. In other words, they're saying it's likely unconstitutional. The reason why I say this is going to hold even if the Attorney General of the United States decides to appeal up to the appeals court and possibly move it to Supreme Court through certiorari, it's based on constitutional principles. The court, and keep in mind whenever they say the court, they're speaking about the acting judge. The court must enforce them. The power of the legislature are defined and limited, and those limits may not be mistaken. In other words, just like the C-19 where they're passing things through the executive department without any actual law, and people are just abiding by it like a bunch of idiots. In this case, the legislative department that actually has the power to pass law on a federal level passed the law. And the judicial interpretation, aka the judicial department of government, is saying, look, you are overstepping your bounds as to certain things you can do and certain things you cannot do, because privacy is the backbone of all those substantive rights enumerated within the Constitution. The powers of legislature are defined and limited. Those limits may not be mistaken or forgotten. The Constitution is written. The citation, the good old Marbury versus Madison. While the court defers to Congress on matters of policy, interpretation of the Constitution is an area. Interpretation. So the Judicial Department interprets law, public law in the United States. The first, also, the statute at large in the United States was the Constitution of the United States. Therefore, interpretation of the Constitution is an area where Congress enjoys no authority. It's not for the court to substitute its view of policy for the legislation which has been passed by Congress. Legislative ingenuity dispatched to meet today's problem is not measured by another standard than our written Constitution, meaning the Constitution still stands even if we have modern day problems than those in 1791 when they ratified it were once facing. It still stands. It never expires. Modern problems may well warrant modern solutions, but modernity does not grant Congress a roving license to legislate outside the boundaries of their timeless written Constitution. Well, they stamp the fact that the Constitution applies regardless of when there are limitations in the departments of government, aka the separation of power clause. The Constitution is not abrogated. Even in a pandemic, the Constitution must stand firm. See, when I tell you there are certain things that I see that's coming, this Corporate Transparency Act was supposed to merge with something that's coming in the year 2030. And many people also see it. Those who know how reality works and are hip to it are nipping it in the bud very early. The acting judge here knows it. Remember, this is 2024. This is not something that was released in 2020. So when they speak of pandemic, they're speaking of the future. And I want you to also see it, because I could have just made a regular text post on Patreon, saying this, but I want you to actually read it. Once you're reading it as you're listening to it, read in between the lines, see the reality of it. If you watch the video on the individual master file, and I show you the correlation between the death master file or the customer account data engine that people loosely call the individual master file, and you correlate that with the Department of Commerce, you see that there's a consistency in the data, what's going on. And if you know other things in the back end that's going on, you will see that something else is coming. And this pandemic that's coming might not really be as clear to many people when it actually hits, but the effect would be so significant that if you think many people walk around in today's world are already depressed, more of those is bound to occur. And that future is what these people are speaking of. Hence, the appropriate measures is an injunction. An injunction is anticipatory of something in the future based on something that occurred in the past. What occurred in the past is the passing of the Corporate Transparency Act. The anticipation of it is the enforcement of it in the future, which will be implemented and merged with something else that's coming in the future. I really want you to see this. It's very, very significant. In the matter before the court, plaintiffs challenge an unprecedented law known as the Corporate Transparency Act. It represents Congress' attempt to combat bad actors' ability to cloak their criminal activities and avail of corporate anonymity. At its most rudimentary level, the CTA, which is Corporate Transparency Act, regulates companies that are registered to do business under state's law and requires those companies to report their ownership, including detailed personal information. I repeat, including detailed personal information about their owners to the federal government on pain of severe penalties, though seemingly benign. This federal mandate marks a drastic twofold departure from history. First, it represents a federal attempt to monitor companies created under state law, a matter our federalist system has left almost exclusively to the several states, meaning separation of power, the sovereign immunities of the states, separate from the federal jurisdiction. By virtue of the state constitution, which is an evidence that each state can govern themselves because they have their own governing law, albeit preserving the integrity of the same substance at a federal level, but nonetheless, each state have their own sovereign powers. And when you see this term federalist, it's a different state of mind and political stance than the trash most people are attached to emotionally in today's world. When they say they're voting, and most of those votes don't even count unless they're electoral college. Moving on, for good reason. Plaintiffs fear this flanking quasi-Orwellian statute and its implication on our dual system of government, meaning state and federal, having their own ability to stand and do their thing simultaneously. And one is trying to usurp the other. Federal trying to usurp the independent state's power by imposing federal law on entities created on a state level, by now requiring state level entities to report to federal entities by submitting and relinquishing private personal information. As a result, plaintiffs contend that the CTA, aka Corporate Transparency Act, violates the promises our Constitution makes to the people and the states. Despite attempting to reconcile the CTA with the Constitution at every turn, the government is unable to provide a court with any tenable theory that the CTA falls within Congress's power. And even in the face of the defense, the court must give Congress the CTA appears likely unconstitutional. Then we're stepping to the fact that something is wrong here because it requires people to basically relinquish their privacy just to do business. And on top of that, it basically overthrows the power of the state to make its own decision as to whether the people doing business and sharecropping their interest in the state by filing fees and updating the owners yearly with the state, whether they want to share it with the federal or not. It just overlooked that and just railroad everybody, the everyday man or woman, and even the sovereign power of the state. So it is likely unconstitutional. Now, the reason why they put this likely is because they know that district courts are just trial stages. It can still be moved up and escalated. District courts don't make the final determination of judicial decisions. The Supreme Court does, because that's the only one court that really exists. All the other that exist on a trial and appeal level are just there as a stepping stone to get to the one Supreme Court. But so far, even on a low trial stage level, they're saying, even if you move this up, it's likely unconstitutional. Even though we know it's unconstitutional based on the principles we just mentioned, but we're not going to be too arrogant and we just say likely rather than just blatantly saying it's unconstitutional. Accordingly, the CTA and its implementing regulations must be enjoined. And then go over the details of how the corporate transparency really came about, how they did a staircase step of elimination to justify why they're saying, hey, look, you must give us your personal information if you want to use trust or engage in any type of business using state sharecropped entities like LLCs, S Corps, C Corps, so and so, which, by the way, S Corps and C Corp is technically the same thing, because S Corp is only different from C Corp just based on the form you fill out after creating a C Corp. So whatever the corp or company that you create on a state level, there was a stepping stone to get to the point where the federal level wanted to basically eliminate the power of the state and the people that comes with it, because the power of the everyday man is tied to the state, whether most people would like to believe that or not. So it gives you a bit of that history, and then it goes into the details of the language of the Corporate Transparency Act, which we went over in the part 1 and part 2, which are the video thumbnails shown earlier. The parties. Remember, it shows among others et al. At the beginning of the case heading. Well, there are 6 plaintiffs in this case, comprised of 1 private individuals and 5. First, Texas Top Cop Shop Incorporated. Texas Top Cop Shop Incorporated is a family-run Texas corporation that maintains its principal place of business and all of its operation in Conroe, Texas, since 2007. Though Texas Top Cop Shop has determined on its own that it is a reporting company under the Corporate Transparency Act, to date, it has not filed a beneficial ownership report with FinCEN. I also show this order within this case law to emphasize that most of the people who say they seek freedom, they don't have the balls. They once more always defer to the agency of comfort of just listening to what other people tell them rather than standing up. Majority of this thing you call freedom is just based on you standing up and speaking up for yourself. Sure, it has to be done with competency. You still need some balls. You still need some solid character and conviction in what you're doing to stand up. If these people talking all this crap about the Constitution actually filed it, the acting judge might have said, well, you consented to it. So what's the point of even speaking up in the first place? Which, when you really closely observe the woes that most people face, because of fear, they fold. But after they fold, they now say, hey, I want to speak up and talk. And when you ask them, well, why did you do that again? That contradicts you trying to speak up. They go, well, it felt this way, or they said, I can't do this. And I'm thinking, so you are here saying you have a right. That's yours. Yet they're convincing you otherwise, and you just fold into it. And now you're trying to double back on it. You have to make your mind up on what you say you are. You have to stand on it. If you're not willing to really go all the way with it, you might as well not even start. But of course, do it with competence and prudence. So here's the history of what occurred in the case, which is the reason why I wouldn't really go over each docket, because, well, this order entails the details that's important in just a few sentences. On May 28, 2024, plaintiffs initiated this lawsuit seeking a declaratory judgment that the CTA is unconstitutional, the Corporate Transparency Act that is, and an injunction against its enforcement. On June 3, 2024, plaintiff moved the court to enter a preliminary injunction against enforcement of the CTA and reporting rule. On June 26, 2024, defendants responded, meaning the Attorney General of the United States, opposing the issuance of any injunctive relief. Plaintiff replied, maintaining that a preliminary injunction is warranted. On September 24, 2024, defendants notified the court of supplemental persuasive authority, After the court set this matter for a hearing, the parties jointly filed a stipulation that negated the need to call witnesses at the hearing. On October 9, 2024, the court heard the argument of counsel. Finally, on October 24, 2024, defendant notified the court of further supplemental persuasive authority. So now they go into principles of equity. Legal standard. A preliminary injunction is an extraordinary remedy never awarded as of right. Meaning, now it's a matter of going through the course of things and seeing all the details within the totality of circumstance. See if it really applies to what you're saying. The party seeking preliminary injunction must establish 4 elements. Here's another reason why I'm showing this specific order. To use this one stone, which is this video, to kill 7 birds at once. We'll go over the elements of a preliminary injunction. A preliminary injunction must establish 4 elements. 1, let me zoom this in. 1, a substantial likelihood of success on the merits. 2, a substantial threat that they will suffer irreparable harm absent injunctive relief. This is usually common. The second element is common in all injunction. 3, that the threatened injury outweighs any damage that the injunction might cause the defendant. And 4, that the injunction will not harm the public interest. A preliminary injunction should only be granted if the plaintiff have clearly carried the burden of persuasion on all 4 requirements. A movement is not required to prove his case in full at preliminary injunction. The decision of whether to grant a preliminary injunction lies within the sound discretion of the district court, meaning it is not by right, it is by looking at the facts involved based on the elements themselves. And it's not self-executing. Plaintiff challenged CTA on several grounds, namely plaintiff assert that the CTA is unconstitutional both facially and as applied and in procedure because the CTA, Corporate Transparency Act, intrudes upon the state's right under the 9th and 10th Amendment. 9th and 10th Amendment says anything that's not enumerated in the Constitution is respectively reserved to the state and the people. Simple as that. Meaning it's no different than you will see all rights reserved in any signature or all rights reserved in any type of watermark or all rights reserved in any type of name of entity at the end somewhere. Well, they did the same thing with the Constitution, and that's being evoked here. 2, the CTA compels speech and burdens plaintiff's right of association in the First Amendment. We went over the importance of right of association being part of about the 4 or 5 rights enumerated in the First Amendment only. So now they're saying, well, speech is the document that you're presenting, which it is. Association is, well, I want to do business strictly by only disclosing certain things with the state, but now the federal is imposing some regulation that's even way worse than that of the state, which is for me to show an ID and name, address, so and so. So 9th and 10th Amendment, First Amendment. The CTA violates the 4th Amendment by compelling disclosure of private information. For each of these reasons, independently and collectively, plaintiffs assert the FinCEN's reporting rule, which implements the CTA, is also unconstitutional and be set aside under subsection 706 of Administrative Procedures Act. In order for a declaratory judgment to be enforced, this must have taken place first. Seeing that first and second part video, why I didn't even tell you, hey, go upload your foreign trustee's passport in there, because I knew it was unconstitutional. You get some people speaking to me through consultation and they're trying to find a way around it by uploading their foreign trustee. And look, don't do it. It sounded a bit discouraging to them, but see for yourself. Sometimes you tell people things over the phone and they just have this bias and this need to fall back on what other people have told them. So they just do it nonetheless. People screw themselves over. And here you have a case telling you it violates First Amendment, 9th, 10th Amendment, and 4th Amendment. Whether the CTA and the reporting rules are absolutely unconstitutional is a question for another day, because they know there's some loopholes by escalating it. Today, it is enough for the court to determine whether plaintiffs have demonstrated a substantial likelihood of success in the merit of any of their claims, in addition to satisfying the three additional elements necessary for preliminary injunction. Before the court can reach the merit of plaintiff's argument, it must dispense with two threshold matters. Namely, the court must perform a dual-pronged stand-in inquiry. First, it must assess whether the individual plaintiff has standing. Second, the court must ensure that the NFIB has associational standing to participate in this litigation on behalf of its member. We won't go into that. Most of this is what occupies the document. So let's just go towards the end. Now, this particular document on Patreon, I'll be uploading this entire 79 page so you can read it yourself. I have a version where I highlighted from my own studies, so I might upload that, or I might just upload this regular one, just so I don't, hinder your own thought process, so you can independently look at it yourself. Yeah, I think I'll just upload this regular one, or both, but that's only available on Patreon. YouTube doesn't allow one to attach uploads of document in videos. Scope of injunction. And well, this injunction that we're setting, this is a limitation of what it's applicable to and the extent of how it can be used. And remember, injunctions for the most part have timeline and time period, which is very important. But as I mentioned in other videos relating to injunction and declaratory actions and whatnot, what most people know about injunctions is, oh, I have an argument with the baby daddy, or I have an argument with someone. Let me go to the court real quick, do an ex parte hearing and do an injunction. Injunctions are supposed to be used against these entities, not your fellow everyday man or woman. Then again, when two brothers are busy fighting, a stranger will come and take their land. If you really want to know how things are done, look at how these businesses are using it. People just hate business, and people just hate money, and people just hate entrepreneurship. People just hate wealth, that they run away from things that benefits them rather than learning and growing. Limitation mindset screw you up. Grow. Scope of injunction. Finally, given that an injunction is appropriate, of course, based on the first 72 or 71 pages prior to this, the court must determine its scope. Meaning now this is a body of enforcement or law of its own. Plaintiffs seek injunctive relief on behalf of the individual plaintiffs, as well as all of NFIB's members, the fellow plaintiff. The government characterizes plaintiffs' requests as one for quote-unquote nationwide injunction, which is one more point and one more reason as to why I'm reading this, because it applies to you. And to those who've yet to even realize it, or to those who are thinking, oh, what do I do now? They're thinking of which fence to stay on. Well, this is for all of you. The government characterizes plaintiffs' request as one for nationwide injunction. At the court's hearing, plaintiffs suggest that they sought an injunction on behalf of only the plaintiffs before the court, including the approximately 300,000 members of NFIB, which, as a premise in the back of your mind, you should realize all of them don't only have properties or interest of business that is limited to Texas. The government responded that if the court were to enjoin the CTA and reporting rules, the scope of which included NFIB's member, then the court would, in practical effect, enter a nationwide injunction, which was part of what was entertained in the previous docket. The court agrees with the government's point. The nationwide injunction is appropriate in this case. A preliminary injunction is an extraordinary equitable remedy. The Constitution vests district court with, quote, the judicial power of the United States. And they reference Article 3, subsection 1. The power is not limited to the district wherein the court sits, but extended across the country because it's federal jurisdiction. That's one of the significance of creating the federal jurisdiction, which they refer to as a more perfect union, as to why they revamped the previous articles, which is association and confederation. It is not beyond the power of a court. It is not beyond the power of the court, meaning it is still within their capacity to issue a nationwide injunction in the appropriate circumstances to issue a nationwide injunction. They give you a reference of it based on that circuit. Upholding nationwide injunction after concluding it was compelled by the text of subsection 706 of Administrative Procedures Act, affirmed in part and revised on the grounds by so-and-so, instructing district court to enter nationwide injunction. quote unquote, courts should not be loathed to issue injunction of general applicability. The injunctive process are a means of effective general compliance with national policy as expressed by Congress. A public policy judge must to carry out, actuated by the spirit of the law, which we've run over in earlier videos in this page on YouTube around 2022, what the spirit of law really means. Okay, just a principle and intent based on nature's law and other maxims. So when you hear spirit of law, they're speaking of maxims. And not begrudgingly, as if it were a newly imposed fiat of presidium, but simply because the court may issue a nationwide injunction does not mean issued in all cases. As the Supreme Court has held, quote, the scope of injunctive relief is dictated by the extent of the violation established, not by geographical context of plaintiff in a class. Meaning, if you are in a federal jurisdiction, even if the venue is in Texas, so long as it's in federal jurisdiction, certain things, particularly in this case, the injunctive relief, which is an equitable or extraordinary relief, can apply to many more people beyond that venue, in this case, beyond Texas. The relief of the court fashion, quote, should be no more burdensome to the defendant than necessary to provide complete relief to the plaintiff. And even if we're doing something beneficial to the plaintiff, we still make sure we're not too much of an a-hole about it to the point where it just makes the defendant bend backwards. So the quote-unquote government have nothing to lose in this case by issuing a nationwide injunction. In fact, they suggested it right here. Plaintiffs are just trying to seek their other members who were at about 300,000 and count. But the defendant, which was the United States Attorney General, mentioned the fact that, well, if you do that, it's basically a nationwide injunction. The court said, yeah, you're right. It is. We might as well just do that then. The Fifth Circuit has approved nationwide injunction in cases involving immigration and the Administrative Procedures Act. Is also held, blah, blah, blah. It just validates the reason why they're about to issue a nationwide injunction because, well, there are precedents regarding it and they're not wrong by doing so. And there's no injury done, so and so. Page 77, the court determines that the injunction should apply nationwide. And you, as you're listening to this, you have an LLC, you should know about this when it comes to the Corporate Transparency Act. So if you have someone who have their own clandestine intent or maybe other people somewhere saying something that are not quite well informed, telling you, oh, no, you have to do the Corporate Transparency Act. Well, as of December 3rd, which was yesterday, 2024, there's an injunction against it. Or that's just part of the scope, and it applies to everyone. But the CTA and the reporting rule apply nationwide to approximately 32.6 million existing reporting companies. And well, since it's dealing with a Corporate Transparency Act that applies nationwide, that means this injunction must also go nationwide. And if IB's membership extended across the country, like I mentioned, those 300,000 people are not just limited to those who do business in Texas. There are other people across other states. And the good part is this is a federal jurisdiction, which applies across all states, which they justified by spilling a bunch of stuff for about 2 pages. And as the government states, the court cannot provide plaintiff a meaningful relief without, in effect, enjoining the CTA and the reporting rule nationwide. The extent of the constitutional violation plaintiffs have shown is best served through a nationwide injunction. Given the extent of the violation, the injunction should apply nationwide. So to repeat it, at the beginning, the paragraph, and at the end of it, they open the seal, close the seal. Moving on. Conclusion. Plaintiffs have satisfied all prerequisites for a preliminary injunction. The court has authority to issue the injunctions plaintiffs seek under Federal Rules of Civil Procedure 65D. You want to do injunction on a federal level? Rule 65. The CTA is likely unconstitutional. They keep using this keyword likely because they know it can still be escalated. And they're saying indirectly without directly stating it blatantly because, an acting judge is supposed to be neutral and not appear as though they're taking sides. And this order itself already blatantly shows that it's to the favor of plaintiffs. So they want to sound as neutral as possible by saying likely. But they're saying likely because they're hinting that, look, even if you move this up, it's still likely going to be affirmed based on what we're saying. CTA, Corporate Transparency Act, is likely unconstitutional as outside of Congress's power. Meaning Congress overstepped their bounds by saying, hey, look, you people on the state level, now all of you come give us your personal information. And 2, all of you now come give us all your businesses. And also, they're telling people to just give them their personal, confidential, sensitive information. And 3, they're forcing people to just associate with them rather than making the free, independent decision to be local rather than foreign, state versus federal. Forcing people to do business with a federal entity, even though their initial intent is to just share crop with the state, like creating LLCs, which are originally state tools. Because the reporting rule implements the CTA, it is likely unconstitutional for the same reason. The court has not addressed the issue of the CTA's constitutionality as applied to these plaintiffs or plaintiffs' challenges under the First and Fourth Amendment. So the reserved right itself is what they're speaking of here. That is sufficient. Having determined the plaintiffs have carried their burden, the court grants plaintiffs' motion for preliminary judgment, meaning they're leaving the door open for Fourth and First Amendment contentions that could be in favor of the defendant, the United States Attorney General, if they choose to attack it when they escalate this. Therefore, the CTA, Corporate Transparency Act, which is in 31 U.S.C. 5336, as we've shown in that first and second video, is hereby enjoined. Meaning this injunction is regarding the Corporate Transparency Act. Enforcement of the reporting rule, 31 CFR 1010.380, is also hereby enjoined. Meaning any enforcement to say, look, if you don't do this, you pay this amount. Well, the injunction also applies to that. And the compliance deadline is stayed under Section 705 of the Administrative Procedures Act. Neither may be enforced, and reporting companies need not comply with CTA's January 1, 2025 BOI reporting deadline pending further order of the court. So this case right here is what you need to keep eye on if you have an LLC, S Corp, C Corp. Because as of now, December 4th, and this was passed on the 3rd, today's the 4th of December 2024, Corporate Transparency Act has been ruled unconstitutional, and an injunction has been placed on it nationwide. It is therefore ordered that plaintiff's motion for preliminary injunction, docket 6, is hereby granted. It is so ordered. Signed this 3rd day of December 2024. Hey, I'm inviting you to come join the patron page. Not only do you get access to documents, posts, and videos that you will never find on any other platforms, you also get instant access to webinars that otherwise will cost far more. And we speak of things that usually we would not be able to speak of on any other platforms far more freely. On top of that, you get the opportunity to send me monthly questions along with everyone else's questions, so you can see other people going through similar circumstances. You never know what you think might be a stupid question. It's quite often very valid. On top of that, you get access to monthly question and answer archives from several years back from people who have gone through it and people who are going through it. Get information regarding things you experience daily that you didn't even know you could take advantage of when it comes to business, work, or other personal things. There's a community of people where you can bounce information off of, and they can give you some tips and tricks based on what they're currently going through in their respective venues that you might maybe want to link up with. And there's a high likelihood you're not going to find them anywhere else. And you also get the access to directly send me messages. Oh, and also if you are a tier 4 member, you get access to yet another monthly meeting where we actually answer as much questions as we can, anywhere between an hour and a half, and in some cases up to 4 hours. In addition to that, we also show some exclusive lessons that are not going to be posted on Patreon or anywhere else but the tier 4 meeting alone. So come forth, come join the 500 plus people already on Patreon. And in some cases, we even give certain things out. And while you're at it, you might want to check out the store, subtlesubstanceservices.com. There might be a few things you want to pick up in there.